Okay, well, good morning, everyone, and a very warm welcome to this, the latest in our series of webinars on voyage charters, with today's subject being laytime. Now, today is the first in two talks on laytime and demurrage, and there've been lots of expressions of interest in these two particular subjects right since the beginning of our talks on time charters. So we thought it best to dedicate two talks to these quite involved and sometimes tricky areas. As always, there's the Birketts at a glance slide, so please take a moment just to have a look at that when you have a bit of spare time. Delivering the talk today will be Henry Adams and I. Good morning, Henry.
Yes, very well. Warm welcome to absolutely everyone from near and far. As Tom said, this is a very topical discussion at the moment, not least because of supply chain issues that are affecting ports around the world. There are plenty of ships, but not enough ports to deal with them. So delays are rife, as are issues from free pratique and COVID. So this is a particularly opportune time to be talking about this.
Thanks, Henry. And so just to introduce the structure of the talk today and the particular topics that we're going to be looking at. First of all, I'll just set out briefly an introduction to laytime and demurrage. Then we'll just have a look at the way that the laytime period is defined in various different charter party forms. And then Henry's going to get stuck into the real meat of the talk today, which relates to the tricky area of the commencement of laytime and the various considerations that apply in relation to the tendering of NORs. And then finally, to wrap things up, we'll have a look at when laytime can stop, when there are certain interruptions and exceptions, and also where there is delay caused by owner's fault. So that broadly is the structure of today's talk. And so without further ado, on to our brief introduction to laytime and demurrage. Okay, so introduction. To summarise the meanings of laytime and demurrage, which are terms that you'll regularly see in voyage charter parties, well, laytime is the time that charterers are permitted to carry out cargo operations. Okay, very simple. The important distinction to keep in your mind is that laytime and the vessel's laycan are completely different issues. So please disassociate these two words in your mind. Laycan is the period during which owners are obliged to deliver a vessel, and laytime is the time permitted to charterers for cargo operations, separate concepts. Demurrage is then the sum in liquidated damages to which owners will be entitled where the charterers go beyond their permitted laytime. Okay, and this is usually set out by reference to a rate in the charter party. But demurrage is, as I've mentioned already, is going to be the subject of the next talk in a couple of weeks' time. So we're not going to look at demurrage in any detail today. And these two concepts of laytime and demurrage were summarised quite neatly in the 1991 case called the Forum Craftsman, where the judge set out that charterers are obliged to discharge the cargo within the permitted time, i.e. the laytime, and then once the time has expired, charterers commit a continuing breach of the charter party until they complete the cargo operations, and the vessel will be on demurrage during that period of continuing breach. Okay, so that in a nutshell is what laytime and demurrage are. But of course, if it were that simple, excuse me, if it were that simple, then we wouldn't need to be doing the two talks that we're currently undertaking. So now let's have a look at the laytime provisions in charter parties in a bit more detail. So moving on, first of all, to have a look at how the laytime period is defined in certain charter party forms. First of all, the GenCon 94 form, where this is dealt with at clause 6. And what clause 6 in the GenCon form provides is the possibility for the parties to the charter to elect a particular laytime regime, subclauses A and subclause A and subclause B, and only one or the other will apply. And the distinction between the two is that subclause A provides for separate laytime for loading and discharging. And the way that it does that is on terms that the cargo shall be loaded within the number of running hours, as indicated in box 16, weather permitting, Sundays and holidays accepted unless used, in which event time actually used shall count. And then it goes on to make the same provision in relation to discharge. Okay, so the important points to note here are first of all the period of running hours to which charterers are entitled. And the term running hours means that laytime runs continuously during both day and night and irrespective of normal working hours. So once laytime has commenced, it will run continuously, subject to any interruptions or exceptions that apply. Now, note also the words in this clause, weather permitting, Sundays and holidays accepted unless used, etc. These amount to interruptions to laytime, and we're going to have a look at those in a bit more detail later in the talk. Just before we move on to look at subclause B, as I mentioned, subclause A provides separate laytime for loading and discharging, and charterers are not entitled to borrow time from one and give to the other in case one particular cargo operation overruns. Okay, they're looked at as distinct operations, and if you overrun for one, then the vessel will be on demurrage. By contrast, subparagraph B, subclause B of clause 6, provides for total laytime for loading and discharging, and this is also referred to as reversible laytime. And in those circumstances, it provides for the total number of running hours as indicated in box 6, with the same interruptions then following. Okay, so the parties can elect to either have separate laytime or reversible laytime pursuant to subclause B. Just to have a look at another couple of voyage charter forms and the way that they address laytime. The Shellvoy 5 form, clause 12, obviously this deals with wet cargoes, and you'll see that the laytime provision is on very similar terms to clause 6 of the GenCon form, where it provides for a particular number of running hours. And again, this is total time for loading, discharging, and all other charterers' purposes, so it's laytime on a reversible basis. The Sino-Comex form, on the other hand, takes a slightly different approach, and it's an approach that you'll commonly see, particularly where bulk cargoes are concerned. And under the Sino-Comex form, the laytime is defined on terms that cargo should be loaded, trimmed and stowed at the risk and expense of the shippers and charterers at the average rate stated in box 14, weather permitting. In box 14 of the charter, the loading rate is then set out in this particular charter party, 1,600 metric tons per weather working day of 24 consecutive hours. So rather than a reference to running hours, the charterers are obliged to keep up with a particular loading rate. And I think clause 15, or maybe later in clause 14, there's also a particular discharging rate that the charterers have to keep up with on discharge. So that's an alternative way of defining the laytime period that you'll often see in charter parties for bulk cargoes. Okay, and now that I've talked about the way that the laytime period is defined, Henry's going to talk about when laytime will commence. So over to Henry.
Thanks very much, Tom. Yes, so on to the bulk of the talk, really, and this is such a fertile area for dispute. The commencement of laytime. And the key document here is, of course, the notice of readiness. This is simply notification by the ship that she's in a state of readiness at the time that the NOR is given. And there are a number of formalities which have to be carefully considered with every NOR. The first point to make is that the NOR doesn't actually have to be given in writing unless the charter party states that it does. For example, the standard GenCon form doesn't require notice in writing, but almost invariably it is given in writing for very obvious reasons that it is then good evidence. To whom does it need to be given? The starting point, of course, is the charterer, but there are charter parties, and again, the GenCon form is an example, which stipulate that at the load port, NOR must be tendered to the shipper, and at the discharge port, it must be tendered to the receiver. So you have to bear that carefully in mind, because if it's not given to the right party, then it won't be valid. There are also occasionally stipulations as to the time of day when NOR must be tendered, and we'll look at a case on that in a moment. But in the absence of anything specific, NOR can be tendered at any time of day. Now, it also has to be in a specific form if that's what the charter party says. In the absence of anything specific contractually agreed, then the NOR simply has to state that the ship has arrived at the place where she may tender NOR under the charter, and we'll look at place in detail in a moment, and that she's ready to discharge. So, this question of timing, we're going to have a quick poll on this, if we may. There was a case called the Peter Schmidt that went to Court of Appeal level, And the charter party, as the slide says, required notice of readiness to be tendered essentially within office hours, but notice of readiness was tendered after that time. So the charterers understandably said, right, the NOR is invalid and will be wholly ineffectual, so time shouldn't run at all. The owners, on the other hand, as you might imagine, said, well, hang on, that would be unduly harsh. Time should run from the next working day, 0600 hours. So the question that I have is, what was the court's conclusion? Did time run from the date, the time at which the NOR might have been received the following day, or did time not run at all? Over to you, if I may. There are the results, and the majority is right. In short, the court took the view that in the circumstances, the key point was the NOR, which in fact was tendered in writing and physically left at the charterers or their agent's office, would have been therefore received the following morning at 0600 hours. So that is when the NOR was deemed to have been tendered, not ineffective, as the charterers argued. And I think the same result would almost certainly apply in the context of NOR tendered by email, which of course is the modern way. So the first question that arises is, when can an NOR be validly tendered? And the answer will always depend on the terms of the charter. And there are essentially two possibilities. A charter party will either be a berth charter or a port charter, both for the load port and the discharge port. And I've set out three possibilities there, and we'll go straight to each one. Sophie, are you able to move the slides on, please? Thank you. So scenario one, the vessel can only tender NOR where the charter party refers to the berth as an agreed place once she's actually berthed, unless the charter party provides otherwise. And the usual way by which the charter party will provide otherwise is a WIB-on clause, or whether in berth or not. And in simple terms, that allows the NOR to be tendered once the ship is within the port limits and ready, if berthing is delayed by congestion. So in a sense, that converts a berth charter to a port charter. Now, sometimes charterers are responsible for nominating the berth, and if they are, then they have to do so in sufficient time to allow the ship to go straight to the berth and berth if the berth is available. But there's no actual requirement for the berth to be available on arrival unless the charter party says so. And the purpose of, for example, a reachable on arrival clause is exactly that, to make that a requirement. And it's effectively a warranty by the charterer that the ship will be able to reach the berth when she arrives. And if she can't, and it isn't limited to congestion for any reason whatsoever, time will run during the resulting delay. So the next scenario, where the charter party refers to a port as the agreed place. Now, where a berth is available under a port charter, the ship has to proceed immediately to the berth and can only tender NOR once she has arrived. But if there's no berth available, the ship must reach a position within the port limits where waiting ships usually lie. And real issues can arise in terms of where the port limits rest. And there are two very contrasting cases that illustrate this well. Now, the first one, the Johanna Oldendorf, establishes in clear terms that as long as the place of waiting is within the legal, fiscal, and administrative area of the port, the ship can tender NOR even though that place may be quite some distance from the port. And in that particular case, 17 miles away. Now, that was a House of Lords decision, and very shortly after that, another House of Lords decision followed it, this time not so favourable to owners. The charter party named a port, Break in northern Germany, but no berth was available when the ship arrived. So she waited at the usual waiting place for that port. But the waiting place wasn't within the legal, fiscal and administrative limits of the port in question. Now the master knew this, so rather craftily he sailed up the river to a position off Break and tendered NOR before returning to the usual waiting place. But the House of Lords was unimpressed. It held that the NOR was not validly tendered for two reasons. Firstly, the vessel hadn't come to rest when tendering, and secondly, the place where she did come to rest wasn't within the port limits. Now, an exception to the rule that the vessel must be within port limits before tendering NOR is if the charter party contains a whip-on clause or similar, which stands for whether in port or not. And under such a provision, the vessel can tender NOR at a customary place of waiting outside the port limits, providing she's ready, of course. The third scenario, where the charter party mentions both the port and a berth within it. Now that's often the case in circumstances of berth charters. They tend to refer to both the port and the berth, and so it can be difficult to determine whether in fact it's a port or berth charter. And this will always depend on the wording of the charter itself, but there are three key rules of construction to apply. Firstly, if a specific berth is named, the charter party is likely to be a berth charter. Secondly, where the charterer has the express option of selecting the berth, and the obvious example is charterer's berth, which I put in rather unimaginatively, but you see it a lot, then the berth will also be deemed to be the destination. But if neither of those are present, then you simply look at the words describing the berth and the port and give prevalence to the first of those. So one safe berth, Ipswich, berth comes first, so it's likely to be a berth charter. On the other hand, Ipswich, one safe berth, and that denotes a port charter. Okay, so we've considered place. We now go on to readiness, which is the other key issue that arises. And in short, the vessel must be ready to load or discharge in all material respects when the NOR is tendered, and the NOR must record this in clear terms. Now, this rule is strictly applied with the result that the NOR is invalid if it's tendered when the vessel isn't ready, even if no delay actually arises. And a very good illustration of this is the case of the Tres Flores. Now, the ship tendered NOR before the holds were fumigated. There was then a delay because no berth was available, during which time the holds were fumigated so that she was ready to load once the berth came free. So no actual delay arose, but the court held that the NOR was invalid, even though there was no delay due to the lack of fumigation. The only circumstances in which the courts won't apply this very strict rule is where the parties expressly agree otherwise. And an example of that was the Linados, where the charter party stated any time lost after tendering NOR by vessels not fulfilling requirements for readiness to load shall not count as time for loading. The court held that the NOR was validly tendered even though the holds were wet and rusty, with time interrupted only for the periods of actual delay after cargo operations. But those clauses are very rare, and in the great majority of instances, the vessel won't be ready, or if the vessel isn't ready when NOR is tendered, then time simply won't run. Next slide. So the question arises, what amounts to readiness? What is readiness? The courts take a commercial, pragmatic view. They describe it as the vessel having to be ready in a business and mercantile sense. And that really is divided up into two different elements. The vessel has to be ready both physically and legally. And we'll look at legal readiness in a moment. Physical readiness, the following elements arise. Now, if there are small or routine matters which preclude the ship's readiness, then those will be excused. And I've given a couple of examples here to compare and contrast. Now, the first instance is hatch covers which haven't been opened. That could take 20 minutes, half an hour, whatever it may take, but the courts will excuse that as not being an example of unreadiness. Contrast that, on the other hand, with situations where, for example, the cargo under a charter party is stowed under the cargo carried under a different charter. So there's going to be a delay during discharging operations whilst the other cargo is discharged first. Now, in those circumstances, the courts will find that the ship is not ready, for the simple reason that it's not fair on the charterers to have to wait for the delay whilst the other cargo is discharged. And that's exactly what happened in a case called the Mexico One. Next slide. So, onto legal readiness. Now, this will include key administrative requirements such as free pratique, customs clearance, immigration, etc. Free pratique in particular is a very hot topic at the moment. That is essentially the granting of confirmation that the ship and the crew are in good health and ready to perform cargo operations, which in a COVID context has given rise to a number of very difficult issues. But readiness won't include mere formalities, in other words, administration that will inevitably be carried out without issue. It doesn't include issues that don't relate to the ship, which is entirely to be expected, and it also doesn't include contractually agreed exceptions such as whether in free pratique or not, which is a common exception. So in those circumstances where you have words, whether in free pratique or not, or whether customs cleared or not, the ship can tender NOR regardless of her free pratique position. Now, I put two further examples down on the slide here because they often present really interesting questions and ones that we commonly see. The first one is, if an owner validly exercises a lien on the cargo, can it still tender notice of readiness? And the short answer to that is yes, it can. And the reason behind this is that it shouldn't be expected that the parties intended that the exercise validly by owners of one right, exercising a lien, should preclude their contractual rights under a different provision, namely their right to tender an NOR. But contrast that with the position where the ship is arrested. That can give rise to some really complex questions. And in my view, the answer will depend on the circumstances. So, for example, if a ship is arrested because of a claim that occurred 5 years ago, so just within the statutory 6-year contractual time limit, then it would seem unduly harsh on owners to say that the ship wasn't legally ready. On the other hand, and we had an instruction on this just last week, where a ship is arrested because the owners are simply failing to pay their mortgage payments for all of their fleet, and in that instance the ship owners own 6 different ships, all of whom were arrested by the banks in question. I think there's a good argument to say that the ship simply wasn't legally ready at the time notice of readiness was tendered. Next slide. So onto the very thorny issue of waiver or estoppel. Now this is crucial, and if there's one case that shipping lawyers tend to know about or refer to in the context of notices of readiness and their validity, it's the Happy Day, a key decision at the turn of the millennium. And the issue is simply whether the charterer can lose the right to argue that an NOR has been invalidly tendered. Now, the fundamental starting point here is that if the vessel isn't ready when NOR is tendered, the NOR doesn't become valid subsequently as and when the ship becomes ready, unless there's conduct on the part of the charterer giving rise to a waiver or an estoppel. And as I say, the leading decision on this is the happy day, and the effect of that decision is as follows. If the charterer accepts the vessel and allows loading or discharging to start without rejecting or reserving rights regarding the validity of the NOR, that is likely to amount to a waiver of the charterer's right to argue that the NOR was invalid when tendered. And time will then run from the start of cargo operations, which is when the waiver is deemed to take place, rather than from when the NOR was tendered. But if the NOR is invalid and charterers do reserve their rights before cargo operations start, effectively the law is undecided as to whether time won't run at all or whether it will run from the start of cargo operations. And if time doesn't run at all, that may allow charterers to claim dispatch, i.e. a sum due to charterers for not using up all the lay time, which was something that was considered both in the Happy Day and an important preceding case, the Mexico 1. And so what do we glean from that? Well, there are two key practical considerations. Firstly, from charterers' perspective, they really need to scrutinise NORs carefully to check whether they've been validly tendered in terms of place and readiness, and should reserve their rights if they think the NOR wasn't tendered at the correct place or the vessel wasn't ready. Owners, on the other hand, are strongly advised to re-tender NOR if the validity of the original NOR is in doubt in any way, whilst reserving their rights as to the validity of the original NOR, for example, by simply saying that the new NOR is without prejudice to the first one. Next slide. Okay, and this is the final slide in terms of the commencement of lay time, and it deals with delays in ability to tender NOR caused by the charterers themselves. And again, this is a sign of the English court's desire to be pragmatic. There are two main examples of this on a practical level. Firstly, the charterers sometimes fail to have cargo ready, or secondly, to obtain the necessary permits, permissions to load or discharge, with the effect that the ship cannot berth. Now, where the charterers have those duties, and for cargo they will always have that duty, it's implied that they must perform it promptly. And if they fail to do so, then depending on what the charter party stipulates, they will be penalised in one of two ways. Either lay time will start early, or the owners will have a claim in damages for detention. So in short, the courts take, as I say, a pragmatic approach to such circumstances, much as they do in relation to delays during cargo operations caused by owners themselves. Onto which, over to you, Tom.
Thank you, Henry. Good. So now that we've taken a look at the ways in which the laytime period can be defined in charters, and we've had a look at the considerations in relation to the commencement of laytime, we're now going to have a look at the circumstances in which laytime can stop running. And as you know, as we've discussed before, the general rule is that laytime will run continuously. And this will generally be the case unless there's a delay that's caused by the ship owner's fault, or there's an interruption or an exception to laytime. And on the following slides, we're going to have a look at each of these in detail. But just before we move on to do that, one important point to consider is that where you see interruptions and exceptions set out for laytime in voyage charters, these will not generally apply once the vessel is on demurrage. And that's an important rule just to keep in mind throughout these talks, but no doubt our colleagues will pick that up in more detail on the demurrage talk in a couple of weeks' time. So first of all, just to consider owner's fault, and we're going to consider owner's fault at two stages in the process. The first is where the owner's fault arises after a valid NOR has been tendered at the load or discharge port, and then we'll contrast that with the situation where the fault arises before the NOR has been tendered. So in circumstances where the NOR has been tendered, as mentioned previously, the general principle is that laytime will run unless the period of delay, the causative period of delay, the event that causes the period of delay is due to the fault of the owner. Now that's relatively straightforward, and there's a well-known case from the end of the 19th century called Budget and Binnington that establishes the principle that owners should not be able to benefit from their own breach in seeking demurrage from delays in cargo operations. The slightly more complex issue in relation to owner's fault post-NOR arises in the question of whether the fault needs to amount to an actionable breach under the Charter Party. And this was an issue that was considered in the Union Amsterdam case in 1982. Now, just to explain that concept in a bit more detail, what happened in that case was that the vessel grounded after a valid NOR had been tendered due to the negligent navigation of the master. Now, in an ordinary situation where the charterers were bringing a claim for breach of the voyage charter due to the negligent navigation or management of the vessel by the master and crew, the owners would have had a defence to that claim pursuant to Article 4.2a of the Hague Rules, which offers a defence in precisely those circumstances. And owners tried to run a similar defence in relation to charterers' position that Laytime paused in these circumstances. But what the court held was that that defence under 4.2a did not assist owners in circumstances where there was a delay post-NOR caused by their fault. And essentially, the concept here is that what charterers are not really bringing a claim in these circumstances. They're offering a defence to a position where otherwise demurrage would be due. And in those circumstances, the 4.2a offence does not help owners, so there is no actionable fault necessary. Now, contrast that with the situation where owner's fault arises before the valid NOR is tendered. Okay, and just to illustrate this, we'll look at the Santa Isabella, which was a 2018 case where we were actually involved on behalf of the successful charterers. And what happens in that case was that there was a delay at the discharge port, but this was due to the cargo deterioration during the voyage, so prior to the tendering of the valid NOR. The owners claimed demurrage, and in those circumstances, in order to defend the demurrage claim, the charterers had to make a cross-claim, which is effectively a counterclaim, in relation to the demurrage liability. And in that situation, charterers' defence had to be based on an actionable breach of the charter party. So just going back to the Union Amsterdam situation, in those circumstances, if the loss in question had been caused by owners' negligent navigation of the vessel, then the owners would potentially have a defence in those circumstances pursuant to the Hague Rules. In the case in hand, in the Santa Isabella, it was a different situation in which the breach by the owners was actually pursuant to their failure to care for the cargo, which amounted to a breach of Article 3.2 of the Hague Rules. In fact, in that particular case, it was a failure to ventilate the cargo during the voyage. That was an actionable breach to which the owners had no defence, and on those terms, the charterer's defence of the demurrage claim did succeed. But as I've explained, if the breach had not been actionable in those circumstances, then owners would have potentially had a defence, and the demurrage claim would have had a defence to charterer's cross-claim, and the demurrage claim could have succeeded, although there were several other issues in play. But that's a good illustration of the difference between when the fault arises pre-NOR as opposed to post-NOR. I hope that's reasonably clear to some people. It's a slightly tricky concept, perhaps slightly above the entry level of some of these talks, but hopefully of interest to some nevertheless. Moving on now to consider some of the interruptions to laytime that can arise where these are provided for in the clause in question. So an example of interruptions that often arises, including, as we saw earlier in clause 6 of the GenCon 94 form, is that Sundays and holidays are often accepted from laytime. Now note that despite the fact that the word accepted is included in this particular provision, this is still an interruption as opposed to an exception, and we'll have a look at why very shortly. The question that arises on these particular words is what is the meaning of holiday? Sunday is fairly obvious, everyone knows what a Sunday is, but how do we determine whether a particular day is a holiday? And the answer is that we have to look at the particular practice and custom of the port in question. That's the relevant place for determining whether a day is a holiday. And where these words are present in a charter party in isolation, it's irrelevant whether work was actually carried out on the Sunday or holiday in question. Even if the work was carried out, these days will still be excluded or amount to an interruption to laytime. However, often these words are qualified by the words set out at the bottom of the slide. So it says Sundays and holidays accepted unless used, in which case time actually used is to count. That's fairly self-explanatory and obviously gives a more commercial result than if charterers were excused late time running on days when cargo operations were actually carried out. On to a second example of an interruption, the words weather permitting that appear again in the clause 6 of the GenCon form. Now, the meaning of the words weather permitting, and indeed the approach to interruptions in voyage charters in general terms, was looked at in the Voras in 1983. What happened in the Voras? There was the laytime period was defined in the particular charter party, which was on the BP voy form, as 72 hours weather permitting, and laytime was to commence 6 hours after the NOR was tendered. When the vessel arrived at the load port, she tendered an NOR, but there was another vessel on the berth, and the port was closed at that time for bad weather. There were then other vessels that called at the berth, other weather delays. Eventually, the Voras got onto the berth. There were more weather delays, and by the time the vessel, the Voras, had actually left the berth, she would have been on demurrage, subject to resolving the approach to the interruptions in the laytime clause. Owners claimed demurrage and argued that only the periods when bad weather prevented the Voras, i.e. the actual vessel, from loading counted as interruptions to laytime. Charterers took a contrary position that actually weather permitting was part of the definition of laytime, and time was interrupted whenever bad weather prevented the loading of any vessel of a similar type to the Voras. Now, this question went to the High Court, and in true time-honoured webinar style, I'd like to pass the question over to the audience, and I'd like your views on whether the High Court preferred owners' restrictive approach to the construction of the interruption, or whether it preferred charterers' broader approach. So who was right here, owners or charterers? And it was indeed the charterers that prevailed. And what the court said in those circumstances, there we go. So the master of the rolls in that case applied the same principle from the earlier case of Reardon-Smith line. And what he said was that the weather prohibited any vessel of this general type from loading. And it's nothing to the point that owing to the presence of another vessel in the berth, the prohibition, i.e. the weather, was not the operative cause which prevented the weather from loading. So in summary, what the judge held was that the fact that weather had to permit the particular cargo operation was actually part of the definition of laytime. And if the weather didn't permit the cargo operation, then laytime wouldn't count, regardless of the direct effect on the vessel in question. He took the general approach preferred by charterers. And that indeed is the principled approach on which one would generally approach the construction of an interruption in a laytime clause. Now, contrast that with the approach to exceptions in laytime clauses. So exceptions do not form part of the laytime definition, and the effect of an exception to laytime is to excuse the charterer's breach or non-performance of cargo operations where there's an accepted event that hinders performance. And like with all exceptions clauses as a matter of English law, a strict construction is applied against the party seeking to rely on the exception. So the burden is on the party relying on the exception to prove that they fall within the scope of the clause. As I mentioned earlier, usually an exceptions clause will not apply once the vessel is on demurrage unless the charter party says so. And it's also worth just keeping in mind that general exception clauses in charter party outside the laytime provisions will not usually apply to laytime. So for example, clause 19 in the Asper tank buoy form, which is a general exception clause, and says that the vessel, her master and owner shall not be responsible for any loss or damage or delay, interestingly, or failure in performing hereunder arising or resulting from the list of accepted events. But that clause 19 will not usually apply to laytime unless there are express words that apply those terms to laytime. Usually we're just looking at the exceptions in the particular laytime provision. But as always, we have to read the charter party as a whole. So another example, an example of an exception to laytime taken from the case of Carboex and Louis Dreyfus in 2011. That case involved a COA, which is a contract of affreightment, which is a series of voyage charters, so the same principles generally apply. And there was an exception to laytime in the laytime provisions that said, in the case of strikes, lockouts, or any other causes beyond the control of the charterers which prevent or delay the discharging, such time is not to count. That's a pretty typical exceptions clause. There was a strike at the port, which was the cause of delays, and as a result of the strike, 4 vessels under the contract of affreightment were delayed in berthing and discharging. There was also a WIB-on clause in the contract of affreightment. Henry discussed WIB-on clauses a bit earlier. And the owners argued that it was only where the strike delayed the discharging of the chartered vessel itself that the clause applied, and not where the delay of the vessel on the berth caused congestion and knock-on delays. Owners also relied on the presence of the WIB-on clause as reinforcing their position in this respect. The charterers, unsurprisingly, took a more general and wider approach to constructing the clause and said that the exception applied to any delay where the strike was the effective cause. Now, it's currently 1-1, charterers and owners. Let's go to our final poll of the webinar, and I'd like you to vote once again on who you think prevailed in these circumstances. Did the Court of Appeal and the High Court, subsequently the Court of Appeal, prefer owners' narrow approach or charterers' broad approach? Excellent. Well, almost impossible to split the audience on this one, marginally coming out in favour of charterers, 52-48. And I can tell you that once again, those who voted for charterers were correct. Now, the court in this particular circumstance held as follows. In this case, went to the Court of Appeal, who held that the natural meaning of the charter provision was that it excused the charterer from delay caused by the strike, whether or not the vessel was in berth, and whether or not the strike was still in progress, as long as the charterer could show that the strike was the effective cause of the delay. And it's that last few words, as long as the charterer could show that the strike was the effective cause of the delay, that really sum up the approach that one would take to determining the meaning of exceptions clauses, not only in laytime provisions like this, but in general terms. And contrast it with the court's findings in relation to interruptions, whereas actually whether or not the event in question was the effective cause of the delay was neither here nor there, because an interruption forms part of the definition. Contrast with the approach to exceptions, where the effective cause of the delay is the key consideration. And on the facts of Carbo X, the charterers were able to establish that the strike was the effective cause of the delay experienced by all of the ships. The court then went on to say that the effect of the WIB-on provision, and remember, WIB-on means whether in berth or not, the effect is that the owners can tender the NOR before the ship is on her berth in a berth charter if there's congestion on the berth or there's already a ship on the berth. So in this situation, the effect of the WIB-on provision was simply that the owner was entitled to give notice of readiness before berthing. It did not affect the question whether the running of laytime was suspended by a particular exception. And so charterers finished this webinar 2-1 up in extra time. And that actually completes the talk. I think we have a couple of questions that I can see. I think we'll bring Henry back in, who I think is going to address the first one of those questions.
Thank you, Tom. Yes, the first question that was raised was, and to paraphrase it very slightly, what is the impact of extraordinary events like the Ever Given? Interesting question. The first point to say in that context is for the Ever Given herself, and indeed for ships that would have been waiting during their voyages rather than waiting to load or to discharge, won't be affected in the context of laytime or demurrage. Laytime and demurrage only deal with loading and discharge. So once the voyage has started, it becomes immaterial. But to take the question slightly wider, of course, one of the impacts of the Ever Given was on supply chains subsequently. And there was enormous congestion as a significant proportion of the world's fleet was liberated from their quagmire of sitting, waiting, and descended on ports at the same time, giving rise to a great degree of congestion. And that is when WIB-on provisions, WIP-on provisions, etc., really come into play and indeed reachable on arrival. So indirectly, the Ever Given had a very material effect, as indeed is the case with some of the supply chain issues arising from Brexit, from the COVID crisis in particular. So another question that has arisen, Tom, you happy to deal with this? How to calculate laytime at time lost in waiting for berth clauses?
Yeah, sure. So I think the easiest way to answer this question is probably to break it down into two parts. And so the first question is how to calculate laytime, just in general terms, first of all. And the answer to that is that you need to look at the clause in the charter party and simply apply it to the facts of the case. So you look at the time that the NOR was tendered, you look at any allowed period of time, for example, 6 hours that's allowed before time will actually start to count. If the lay time refers to running hours, then time will then run continuously, subject to any interruptions or exceptions that apply. And of course, charterers in the modern world have quite sophisticated software where you feed all this information into the software and it runs the calculation for you. So generally speaking, the ship will arrive at the, let's say, will arrive at the berth. If she's able to get onto the berth, NOR is tendered, time will then run in accordance with the charter party. If, on the other hand, there's a provision in the charter party, like a WIB-on provision, or a provision that says time lost in waiting for berth to be for charterer's account or something along those lines, then obviously that entitles the owners to tender an NOR earlier, notwithstanding that the vessel can't get on the berth, and shifts the responsibility for the delay to charterers, providing that a valid NOR is tendered. So the process really of calculating lay time in those circumstances is just the same as if a valid NOR were tendered on the berth, but just allowing for the fact that the NOR is justifiably and validly tendered earlier. And essentially it means that lay time will run from an earlier time that it otherwise would, and shifts the risk of that delay onto charterers in those circumstances. So I hope that answers that question. And then Henry, I think we've got one more here, unless any others have popped up, which, there might be one more after this, but if we address this one first. So if a vessel arrives outside the lay can, is it understood that time to count upon commencement of loading?
Well, the first point to make on that, and I think it was on your very first slide, is to distinguish between lay can and lay time. And lay can is simply the period during which the vessel needs to arrive so that she can load the cargo. If she arrives outside that time, later than that time, then that can entitle the charterer, or does entitle the charterer, to cancel the charter party. But if the charter goes ahead, then that's when lay time will kick in. And in the normal course of events, time will run from the tendering of a valid NOR. There are exceptions to that. For example, the ASBA tank buoy provides a grace period of 6 hours from when time will run. Other contracts provide similarly. And of course, we looked at the Happy Day, which provides for what happens when NOR is tendered on an invalid basis, and then time will count actually from the loading or discharging operation itself. So it's very important to distinguish between lay can and lay time in that context.
Thanks, Henry.
And Tom, you've seen one final question, have you?
Yes, so we've had one other question that says, could you please clarify the kind of situations envisaged by the phrase all others charterers purposes whatsoever under clause 12 of the Shell-Voy 5? If we just go back to that, so as mentioned in the question, so the Shell Time 5 clause that you can see there says that the lay time will run for loading, discharging, and all other charterers purposes whatsoever, and that should be included in the running hours. To give an example of a particular charterer's purpose, putting me on the spot slightly, nothing exactly immediately springs to mind, but I think what this provision is getting at in general terms is just clarifying that anything that takes place during the period of lay time, whether or not it's to do with loading and discharging, will fall within lay time, and will be covered by the permitted time. So I suppose if charterers need to make provisions for the vessel during loading operations, for example, So taking on board provisions for the voyage, for example, that don't actually really coincide with loading, that would also be covered by the running hours. And I think it's scenarios like that, really. It's clarifying that it really captures any of the circumstances that could arise. I'm sorry if that's a slightly vague answer to the question, but that's all that springs to mind at the moment.
I had a similar thought. I cannot think of any particular operations, given that this is all in the context of a voyage charter, not a time charter, which would be so much wider in terms of the charterer's own operations. But the key point here is that this, again, it goes back to the answer I gave in relation to the ever given. It all relates to the periods for loading and discharging. So it's a catch-all provision that I have never had cause to consider in any detail, because all of the issues that I've ever seen on in relation to Laytime have dealt with loading and discharging and not with any ancillary purposes. But if it was an ancillary purpose, it would have to be essentially during those operations. It could, for example, be shifting to a different berth on charterer's whim. That's just an example.
Thanks, Henry. And then we've got one more question here, Henry. I hope you don't mind me putting you on the spot, but I think this falls within questions relating to NORs and commencement of laytime. And the question is, if the vessel tenders an NOR and fails a cargo hold inspection at the load port, will the NOR be valid from the time the vessel tenders NOR again, or only once the surveyor clears the cargo hold inspection?
Very good question. The key point here is that the NOR will only be valid once the ship is ready. And readiness isn't necessarily linked to a valid certificate or inspection result. Readiness is a state of fact, and therefore once the ship is materially ready, so for example, if there's an hour's delay between the holes being prepared and a surveyor stating she's now ready, then NOR can be tendered as soon as she is actually ready, and then time will run from that moment, and the previous NOR will simply be invalid because the ship wasn't ready at that time. And some of the cases that I referred to, for example, the Tres Flores dealing with fumigation, dealing with wet or rusty holes, go to exactly that point.
Great. Well, I think we've addressed all the questions. If anything else arises, then obviously please do feel free to contact us after the talk. But otherwise, I think that concludes things. And thank you very much for your time.
Thank you very much indeed.